Welcome. In today's session, we will look into more about the Child Support Enforcement Agency as to whether it's a corporation or the government. As most of us were involved in this, we understand that it is a corporation, but in this episode, we're going to look closer. Hello, my name is Chris, and in this session, we will look at the status of the Child Support Enforcement Agency, whether it's a corporation or a government. We'll look closely at that question. But the focus really is how this interferes with your rights. Let's get started. So what does that boils down to? Very simple. Child support is nothing more than a business. It is a corporation, it's a private agency. Sometimes it works from the Attorney General office in Texas, and many states do provide that, but they do that or conduct that via contracts. It is all about the contracts. In this case, in 2018, total of $28.5 billion were collected in child support, and they paid out $27.4 billion. Doing the quick math, there's about $1.1 billion that's sitting out there that participates in the child support program, and it's available to the incentive pools for those who choose to participate. So here are the top 5 states that collects about 25% of all the child supports that are out there. Obviously, Texas is number 1 at 4.2, and we have several videos that we've covered on this, and California is 2.3. The reason why we highlighted California in this chart is California's population is about 39 million. Texas's population is about 19 million. That is, California has twice as many people than Texas. How is it that Texas is able to collect twice as much funds from half the number of people than California? Could it be because of those contracts, those lucrative incentive pools? If you have any question, please feel free to ask us here. I'd love to get your feedback on this. Now, child support, as you know, is what is called a single and separate agency. And we often say this. In 2019, they made about $1.1 billion. That is, for every $5 that $1 that they spend, they make about $5 back in profits. So let's talk about the case law versus the Constitution and state codes. Well, we go to what is called the Federal Statute for the Child Support Agency, and that is found under 45 CFR 302.17, and that it says the inclusion of state statutes. It reads that the state plan provide a copy of the state statutes, regulations, as well as codes and laws that would help do what? It will do 3 things: determine the paternity of the child, establish child support, and enforce support obligations, and in some cases, spousal support. So this is the part of the statute that says include states' codes. Now, often you'll hear judges, when you submit paperwork, they said, well, we don't accept constitutional laws, we don't constitutional decision. That is 100% wrong. The statute here clearly says inclusion, meaning what? Because child support is a federal program, then all of the federal laws and codes apply. Now, in order for the states to carry out the functions under the child support program, Title 4D, they include state statutes, which means you could do this without including the state statute. You could use constitutional or federal codes. So let's look into that further. In New Hampshire, they recently changed the rules that says, there's a rule now that says, Rule 1.2, they could waive the state rules and statutes under the family law. Well, if you were to just use state statutes or state laws, as some of these judges and magistrates tells you, but what if they decide to waive them? That is, no longer consider them. Now what do? Well, this is one area here in New Hampshire where the Constitution and federal codes will always apply. And this waiver, then this waiver becomes irrelevant. This is a case in Texas called Knox versus State. And what I like about this state, it says this. The construct, that is, if you have one constitutional law and it's up against or conflicts with what is called the interpretation of a state code, then what they're saying here is that the Constitution will always win. And what it says here is that the state legislators, in enacting local laws and states, must avoid what is called unconstitutional procedures. Because why? If they pass a statute or a code that goes against any provisions within the federal code or the Constitution wins at every time. And since this is a case in Texas, you could apply Texas to every case. You can apply the Constitution to every case in Texas. And to go further, Texas is in what is called the Fifth Circuit. That includes Mississippi and Louisiana. You, again, if you're in those states, you could use constitutional codes in your child support. So child support. Where exactly is child support when it comes to the courts? Well, in the case law, U.S. versus Sage, that's the Second Circuit out of New York, it says that child support agreements are equivalent to interstate contracts and reject the idea that child support payments are anything but that. So, on this channel, we said this over and over. Child support is a contract. Now, I would add this particular case, Thompson versus Clark, to our already existing, the 5 Supreme Court cases you should already know, and I would strongly encourage you to learn these 5 by visiting our website, which is childsupport.newsendler.com. where you can learn more about these 5 case laws, as well as add this particular law, and we'll explain further. So this is a follow-on to segments that we've done on what is called using the Department of Justice letter of 2016. We created 5 categories in which that you can bring a lawsuit. Well, let's review Harrison County, Ohio. This is where the clerks signs a contract with the child support agency. So here it is, and says Harrison County. They submit and renew the IDV contract for the past 17 years. Yes, it is a contract. Now, under the contract of Title 4D, they ask for and request the services of the court and magistrate. And in this contract, it was signed back in 2019. It's $230.50, and it's solely devoted to the issues of child support. That includes judges' time, the clerks, and everyone else who touches the case. Now, what's significant about this is that 1/3 of the cost is paid by your county, which is your tax dollars, but 2/3 of it is reimbursed by the child support agency. Now, many of you will say that's a conflict of interest. Not necessarily. It's just a contract issue. So when the clerk blocks your paperwork, is the clerk acting as a public officer, or is the clerk acting as a contractor for Title 4D? It is our opinion that the clerks are acting in a contract position and they feel that they can block your paperwork. This is a point of contention, and this is where you double down on your paperwork before the court. Because again, you have a constitutional right to access the court. Now, if you have any questions on what we've covered in this video or any other video, please feel free to email us at chrish289@protonmail.com. And we do ask, please subscribe. If you're new here, please subscribe. If you're old, also, please hit the subscribe button again, as well as the notification bell. And as always, we bring you this information. We do our research, and all we're asking for are small donation to help us to continue